Okay, so the topic for today is a workers' compensation category and specifically the statute of limitations. And while there may be many circumstances that this may come up, and this video may not cover every single possibility, it'll give a good framework for kind of how to start the analysis. At the time of the filming of this video, the statute of limitations in South Carolina for workers' compensation for a state case is 2-year statute of limitation. For a longshore and harbor workers' compensation case is a 1-year statute of limitations. And if you have any type of case for Jones Act seaman or for a railroad employee, which is under the FELA, F-E-L-A Act, Federal Employees Liability Act, consult with the lawyer. Do not, and by the way, on any of these, consult with the lawyer so you know what it is in the year and month that you are watching this video. But for now, it's a 2-year statute of limitations. The same concept will apply against any type of work-related injury that I'm about to tell you about, and that is this. The statute of limitations, the best practices is when we sign up, we send a 2-page letter that's per the statute and the regulations under Title 42 and the regulations that have been promulgated by the Workers' Compensation Commission. And if you send the 2-page letter, and we've got a form letter that's already created, it's already got everything on there, you change the names and addresses to protect the guilty. If you send that in, it will toll the statute of limitations. However, we don't just rely on that 2-page letter. We do have a tickler system for any statute of limitation in any case, and certainly for workers' compensation cases. And 6 months before that statute will run, you will want to file a Form 50. Now, if you're not ready to go to trial, you simply check the box that it's not requesting a hearing at this time. But that 50 is the absolute way that you can also toll the statute of limitations. The next question comes, well, what if we're representing the client, or maybe they come to us after the 2 years? Is their case time barred? And the answer is maybe. As a general rule, there's something called the Discovery Doctrine. And the Discovery Doctrine says that the claimant needs to bring the case within 2 years of when they knew or should have known to bring the case. So for example, if someone were to go in and have a surgery and a sponge was left inside them and they didn't know it, and then 3 years later they go and an x-ray shows that there's a sponge inside of them, and they had that surgery because of the workers' comp case, we would say, hey, he couldn't have possibly known about it. He couldn't have brought a case to get that sponge removed. Now that he knows about it, the 2 years starts to run. Okay, so that's one scenario. Another one is called waiver and estoppel, and that's based upon the conduct of the employer or the insurance carrier or both. So if an insurance carrier makes the initial filings with the commission, accepts the claim, starts benefits, they can't then, when the statute runs, go, oh, statute of limitations, you're barred now. Because their conduct of accepting the claim and paying benefits has put the claimant to sleep, so to speak. It has kept him, and he's relied on their acceptance of his case to not take further action because it wasn't necessary. So they've waived their ability to raise that defense. Now they may raise it, but arguably they've waived it and likely would lose in that fact pattern and scenario. And there's an estoppel because the claimant detrimentally relied upon. He said, hey, you're paying the benefits. Why would I file for a hearing or for a claim because you're already telling me I've got a claim? And they're not sophisticated. They don't have to be sophisticated. So the conduct of the employer, sometimes the employer will just pay money under the table and not even tell the insurance company, and then say, oh, statute came up. Well, their conduct has kept the claimant from taking the affirmative steps because they didn't think they need to. It's going to be a waiver or estoppel issue, and more than likely you'd win that case. Of course, every case is on a facts and circumstance basis, but as a practical matter, if you go to the commission and there's an active claim, the statute of limitations, we still would want to follow the best practices, send the 2-page letter, file the 50 anytime in that 6-month window if we had the opportunity. But if the client contacts us after that, it's not all over. Check the commission. If it's there, file it. Also, you may just file it anyway. Sometimes you've got an adjuster who's asleep at the wheel, doesn't even understand that the statute is run and just accepts the claim. So, you don't know until you file. If you file, then they say no, well, then you know they've got a defense. Then the question is it a strong, medium, or weak defense? And based upon the outline of what I'm telling you to do to analyze in this video, you can assess strength and weakness in your case. That's the end of this video.